I need anybody. I'll actually just dismiss the case and walk away if anybody can show me where I signed a mediation settlement agreement. Just produce the mediation settlement agreement. Because what I can do for everybody, because I think we can share screens here, is I'll just pull up what I know I signed, and we can go over what I did sign at the settlement conference on October 21st, I believe, on October 28th, 2021. And if you will grant me a
couple. I'll let you share the screen, Mr. Doss, and I know it's in the file too. I read it last night, but.
And also, I think we're in the abundance of caution. I need to also let everybody know, as everybody's been served, as well as you have with my writ of prohibition. They haven't ruled on. I just want to make sure everybody knows on the record that I did file it and did pay the subsequent fees. So let's do this. I'm kind of okay at doing this. This is actually what I filed, which is a stipulation, or sign, which is a stipulation of the parties. Let's see. Does everybody see my screen now?
It's about to. Coming up, it says you started it. I don't know if you have to double click to enter full screen mode.
It should be showing you my, let's see. You all, no one sees my screen? It says stipulation of the parties?
Nope. No, it's just black.
I know it's I think you might have to allow me to share my screen.
Oh, there it is. I did. There we go. Now it's up.
Okay. All right. There we go. So as we all see clearly on the screen is what we call a stipulation of the party. Everybody's saying it's a mediation settlement agreement, but I know the document is what it says it is. But let's roll down to here. This agreement releases the following: Chandra Denise Tucker, Linda Tucker, State Farm Mutual Automobile Insurance Company, and other State Farm entities and its employees, Austin Road, Basco, PA, and its employees, the United States Department of Veterans Affairs, which actually is a defendant in this case, and they have yet to appear. I think it's just unfair to have this without them being there. I guess I could file a default against the United States government and have them deal with it. Their employees, Dr. John Shim, Shim Spine, his affiliated companies, and they're going to satisfy the lien. But right here, number 5, which is clear, the plaintiff shall voluntarily, which is going to come up, dismiss this litigation, which is this litigation is 18 Charlie Alpha 3553. That's clear. And unless somebody's going to show me a mediation settlement agreement where I agreed to something else, and again, I'll just step away from the whole case. You better show me a mediation settlement agreement, not a stipulation of the parties. And we're going to go down right here. Let's see. This stipulation, if you go down to number 9, becomes binding upon the parties by their execution and that of their counsel. Now, that's in the plain language of the stipulation of the parties. I want to roll backwards as well, and I don't have to tell everybody because you all are attorneys. You're all seasoned attorneys. In your firms, I've done my research, are comprised of about 170 attorneys and staff. It's surprising to me that you all had to stoop this low to try to cheat a pro se litigant and a disabled American veteran. But we're going to get into something. Florida Rule of Civil Procedure 1.720E makes it clear that before any mediation can be conducted, the parties who will be represented must sign a certification of attendance and authority. Mr. Doss didn't make up the rules. That was never done with the exception of Mr. Rowe, who filed one for Chandra and Linda Tucker. So here's where the fraud comes in. The fraud and the inducement comes in. An attorney, and I'm not one, don't pretend to be one, can never use deception or artifice to pull in a person into a proceeding. He did it. And essentially, the mediation is void. Not essentially, by law, as an operational law, the mediation conference is void. And I have representatives of some major law firms attempting to progress a void mediation. And Judge Huey, I did let you know that you're going to be a witness in my case. I'm in the the 11th Circuit now, Court of Appeals. and you knew that you were going to be a witness because you were a party. You were the presiding judge in a case that involved a property that was also purchased by the person who sold me the properties in another matter. So I'd ask you to suspend dismiss, to recuse yourself. But I want to make sure I put this other stuff on the record. What each one of you all did is walk into the Second District Court of Appeals and furthered a false, misleading, intentionally misrepresenting, and deliberately omitting narrative. GregdossGDNAPSC never signed a mediation settlement agreement. He signed a stipulation of the parties. And after he signed the stipulation of the parties, we had a hearing on January 6th, 2022, odd day, a year later, of course, where Judge Emily Peacock, among just short of calling me nigga, told me not to argue with Mr. Rowe. She ordered me to sign Mr. Rowe's drafted release that had language that was never litigated. And by the way, none of your parties were a part of the original litigation. Hence, the court had no jurisdiction over those parties. Now, I don't expect you to do what would be proper anyway, because I've been with the 13th Judicial Circuit, and rarely do I see judges and lawyers for some reason operate honorably, but that's a different issue. Clearly on here, the court finds that the plaintiff, GregdossGDNAPSC, signed the stipulation of the parties pursuant to the mediation conference. Yes, I did. The court orders that pursuant to the settlement agreement included as A to the defendant's motion to enforce, I shall, meaning I must sign this. And by the way, we all know that as a matter of law, as long as I understand what the judge says, I can't just disregard it. So she forced me to sign this through coercion that included parties that we never talked about this stuff about. None of you all made an appearance at the mediation conference. In fact, Stephen Chauvinik, who was an attorney for the United States government, didn't even make sign the certification of attendance and authority. And he shows up and doesn't even tell me who he is. I think it's pretty odd that, by the way, for you all who don't know, you attorneys have read everything I've filed, and I'm sure you follow me. Title 18, United States Code, Section 208 is a crime. And court reporter, if I'm flowing a little bit too quickly, just slow me down and I'll slow down. I forgot about you. But Title 18, United States Code, Section 208 is a federal crime. You all colluded to allow Austin Road Basketball Professional Association and Dr. John Shem, and I don't want to say the United States government, we're going to find out, to commit criminal activity. You do have an obligation to tell me that Dr. Shem works for the VA. And the fact that you said that is disrespectful to the people who may actually now be in more harm because of the events that occurred on Saturday. Only 6% of us put on a uniform. And to have somebody tell me that a veteran who was willing to put his life on the line with other veterans does not have a right to know that their doctor is compromised, that's insulting. But let's get right here. Should the plaintiff fail to sign the release within 10 days of this order, the release shall be enforceable as if the plaintiff executed the release. And we'll go right back here. And there we go where Judge Emily Ann Peacock says, okay, so Mr. Doss, you're not going to argue with Mr. Rowe during my hearing. Do you understand? That's disrespectful. Secondarily, so I'm entering an order that enforces the terms of the signed mediation settlement agreement. That doesn't exist. And if it exists, I need, whether it's Tabitha Blackwell, Michael Rowe, Scott Gavin, Judge Huey, or Mr. Wymuller to produce the mediation settlement agreement, not the stipulation of the parties. And we're not going to change the title. Now, let's continue on. Do I have to pull up I'm going to do this for the sake of edification about the certification of attendance and authority.